Hi, all, and I welcome all the participants and our speakers to this wonderful session which is coming up and which is our panel discussion two for the day. So, the topic for the panel discussion two is IP enforcement strategies, how to demonstrate value to the business. We have our eminent speakers joining in Kevin P. Olive. He's a brand protection manager, US and Canada, UL LLC. We have Soji John. He's a senior director, assistant general counsel, IP and licensing, Western Digital. We have Michael Sharp, senior legal counsel and head of intellectual property, Aurora Cannabis Inc. We have Pankaj Monga. He's a partner, brand protection, investigation, enforcement, risk management, and strategy practice, Lall and Sethi. And he's also one of our sponsor, virtual platform sponsor. And you can also see him on stage, his firm, and other details. So over to you all for the wonderful session. Thank you.
Sure. Yes. Thank you very much. And yeah, as mentioned, we don't have a moderator for this session, so it may be a little different than some of the other sessions. But what we plan to do is go through the four of us, talk a little bit, give a bit about background about ourselves, and then get into some topics of interest that we think we can bring as a contribution to this discussion. We are going to leave it open for questions and discussions between us as we go along, and hopefully we inspire some questions from the audience as well that we can take, as we go along, or definitely at the end. I believe it's 45-minute session, with 5 minutes of questions as well. So with that, I'd like to start to be the first of the group to go. As mentioned, I'm Michael Sharp. I'm currently with Aurora Cannabis Inc. I'm in Canada. By way of background, I'm an IP lawyer, I'm a patent agent, I'm a trademark agent. I had spent about 12 years in private practice, working with a variety of different industries. Really, really exciting stuff. I'm an IP nerd and love all aspects of IP. I started working with Aurora Cannabis as a client in 2016. So I have about 5 years experience working in cannabis IP specifically, and at a time where they were growing quite dramatically, I went in-house with them about 2.5 years ago and became the head of the IP department. And so I still handle both patents and trademarks, licensing issues, copyright issues when they arise, a variety of different things. So this topic spoke to me because as I was making my transition from private practice to going in-house, I had asked some lawyers that I knew that were already in-house, and one of the things that kept coming up was, always show value and always demonstrate value. And that was something that was new to me from private practice. You send in your timesheet, you get your receipts, you're automatically showing value by what you do. It's not something you have to go out of your way to accomplish. So something new I had to learn, wrap my head around, and be conscious of. And then also, the other aspect of the topic, enforcing intellectual property also spoke to me quite well, because our industry is a newer industry. In the first few years of cannabis legalization in Canada, a lot of time has been spent establishing IP rights, and we're just on the cusp of getting into these enforcement issues where people have drawn their lines in the sand, and now we want to protect our boundaries and we want to assert ourselves. And that's just the start of it for the cannabis industry, at least in Canada and the US we see as well. So very interesting topic to me. I was more on the prosecution end in private practice, so I do have some IP litigation experience, but that's not what I was doing full time by any means. And now, as those opportunities for enforcement arise, or when you're defending these things, you can see the time involvement, and I'm curious about how much of my day-to-day and my bandwidth will be taken up by enforcement issues, and it'll be certainly more and more all the time. So one thing I wanted to talk about at the start is, in terms of demonstrating value, is sort of knowing your audience. I think a challenge with emerging industries such as the cannabis industry, but others as well, is that you have a lot of people coming from a lot of different backgrounds. The IP sophistication at your company could be fairly low. And how can you demonstrate value to someone that's not speaking the same language as you, or someone who doesn't know much about IP and needs to be educated a little bit. And so you need to have that opportunity to assess who your target audience is in your company, and what their level of sophistication is. And is it going to be the CEO? Is it going to be the CFO? Is it going to be the board of directors? Is it going to be the shareholders? And where are they at? And what do they need to know? So it's all fine and dandy to in your head go off on a strategy to demonstrate value, but if it's not resonating with the audience who wants to know what the value is, that's another challenge. So you do want to start from a point of understanding who you're talking with, and what they want to hear, and how you can communicate it to them. So what they see as value might be different than what you see as value. So I do think that's an important aspect at the beginning. Related to that is a comment we get batted around, and I hear from a variety of people, well, what good is IP? What good is investing into IP if it can't be enforced? And so that's a challenge in emerging industries, and it has its own challenges in the cannabis industry as well. I do think that there are situations where IP has inherent value that doesn't necessarily relate to its enforceability. That's outside of today's topic, but I think that personally, and I think a lot of IP practitioners would agree, that enforcement is one facet of IP, but there's other ways your IP could have value, even if you're not currently enforcing it. So with that statement, I hear that, and I realize that's an opportunity that I have to communicate and demonstrate this value, and say, okay, well, this IP is enforceable, but we're not just going to go out and enforce it in a vacuum. The situation has to be correct. We have to know who our competitors are. We have to know where they're heading. We have to know the strength of our assets, and we have to know how a court may handle the enforcement issue, or another adjudicator or panel, or whatever it may be. And that's quite challenging in a new industry, whether it's cannabis or not. All of that's sort of untested. You might not have truly set up, your own company's identity as far as, a variety of things, including your stance on IP enforcement and how hard you go at things, or how you handle things in a collegial manner, or whatever it might be. That is untested. You don't know how your competitors are going to handle things. I was speaking with someone in energy yesterday, and she knows how every one of her competitors is going to handle a situation, because they've been around for decades. And they say, I know that this group is going to do these things this way. I know that this group is going to let this stuff slide. I know if we start a fight with these guys, then they're going to come at us full force, all sorts of stuff. And in emerging industry, you really don't know that. And certainly in cannabis, we don't know that. We have our suspicions, and we educate ourselves, and we handle ourselves appropriately. More specifically with cannabis, it obviously has this challenging nature when it's gone from an illicit market into a legal but highly regulated market. So in Canada, cannabis is federally legal but highly regulated. In the U.S., it's a patchwork where there's legalization for medical and non-medical uses in different states, but not federally legal. And so what that means is it's difficult to establish trademark rights, for example. You can get patents around cannabis technologies, because you can tell the difference between the two things. If you apply for a patent, it doesn't necessarily mean you're practicing that invention in that country. You never make statements of that, at least in North America. I know there's jurisdictions where you have to practice the invention and show that. But on trademarks, particularly in the US, you're basically saying you're using that mark with that good or services that is federally illegal, and that's very problematic. So establishing these rights is one thing. It's challenging. But once you have them, how far do you want to push them? You feel like they might be vulnerable, and everybody in the industry feels this way. So the lawsuits we've seen have been very few and far between on enforcement, because people are still testing the waters. We do see some lawsuits around hemp extraction and things like that. sort of on a spectrum of least controversial to most controversial, and you don't know how a court's going to handle that subject matter. So these are different types of challenges that we face, and again, I want to tie it back to emerging industries and the topic as well, is that you have to have a variety of strategies in your back pocket. You have to be flexible and creative, and again, always try to show value when you can. And I think I've probably taken enough time up, so I'll definitely hand it off to the next speaker.
Hey, Pankaj, Kevin, if you guys don't mind, I think my topics kind of ping along with Michael's. So
Sure.
if you don't mind if I go next.
Sure, absolutely.
Yeah, go ahead, Soji.
Yeah, so just to give you a little bit of background on myself, I've worked on IP and patents from many sides of the issue. When I was in graduate school, my dissertation work was on silicon germanium semiconductor research. Coming out of that, I worked in Texas Instruments as a designer, as a semiconductor expert for a decade about before I went off and did my schooling in law, and then I worked at Jones Day, a large litigation firm working on IP litigation. So I've seen patents as an inventor. I've seen patents enforcing patents from the litigation side, and SanDisk was one of our clients at Jones Day, and I had a good working relationship with them, and I understood the technology very well because of my semiconductor background. So I went in-house at SanDisk, where I started doing technology licensing, patent licensing, and my background in both the semiconductor industry, the litigation background, came in handy. And so at this point, back in 2016 or so, Western Digital acquired SanDisk for their NAND technology. Western Digital, you may know, is a hard drive company historically. NAND is a natural extension for their technology, SSDs, flash drives, etc. And I've taken over the work in monetizing their semiconductor portfolio, in their patent strategy, as well as managing their SD card licensing business. You're almost, I'm sure everybody's familiar with the SD cards, which goes cameras, for example, cell phones, micro SD cards. SanDisk was one of the founders of the SD3C, which licenses that technology, and we have a board seat. So we manage the licensing of the technology. So from all these, a lot of what Michael was saying resonates with the work that I do and what I've seen. The patent, how management views patents has changed from my relation based on when I was at SanDisk versus Western Digital. SanDisk was I guess you could consider them, at one point at least, they were an emerging technology company. And so patents at that point were the lifeblood of the company. And nobody in management, the founders, would never have argued that, or even asked, is this patent important? Get all the patents you can for all the technology that you develop. And regardless of how it was used, because it was viewed as so important by the founders. At some point, the market, there's an inflection in the market, and SanDisk technology is being adopted by others, and it's at that point that we have to decide in SanDisk how to license the technology, whether to license or not, and whether that brings opportunities for the growth of the industry itself, or whether how do we want to play in the markets? Do we want to hold the lion's share? Do we want to bring others into the market to grow the market? So those are decisions that we want to make, and we use our licensing strategy to develop the market, or do we want to keep others out of the market and keep it to ourselves? And that's a way, and that's a patent strategy that we can apply. And we've done both we've done both. We've licensed our competitors. We've kept other infringers out of the market when needed, or not necessarily out of the market, but we need to have them licensed to use our technology, and we take our patents very seriously. But as your technology matures, and as Western Digital has acquired SanDisk, now the patent portfolio has gotten to be in tens of thousands of or I shouldn't say tens of thousands, over 10,000 patents, and keeping a portfolio of that size is very costly, and getting new patents is very costly, and management questions, or rightly so, how we're using a tons of millions of dollars every year in out of the revenue that the company generates in order to get new patents or keep the patents that we have. So we have to demonstrate the value to our management. And two of the ways, I mean, we do it in multiple ways. As Michael was saying, patents enforcement is not the only method of that patents bring value. For example, we're in our hard drive technology, we are one of three main players in the hard drive industry. We don't necessarily have to go and enforce or even license our patents, because it's a mad scenario where we all have patents that apply against each other's technology. We are all pretty much the same standing in the marketplace, and it doesn't make a whole lot of sense to even without a true cross license, we are cross licensed effectively. So that's one way that without even enforcement, we need a patent portfolio in our hard drive to preserve this mad scenario. Because if we stop retaining new or attaining new patents, then we fall back versus our competitors. So that's one way. That's not one of the aspects I planned on talking about, but one way we have one of the ways we try to get some value for the company is divesting our patents, and we have to be careful about what we divest, because we have to look at our portfolio and make sure that we're not leaving holes in the portfolio. We have to see what we're attaining for the divestiture. But one of the I guess trade-offs also is that when we're divesting patents, we are truly divesting the patents to an entity that will then monetize the patents. And we, unless we want to get pulled into the litigation, which we do not want to do, which is eventually there is a potential for some litigation from these third parties. We have to make sure that we don't have control over the patent, and in doing so, we also have to make sure that we are not, because this is a side business to us. This is not our main business is selling our products. We don't want to create tensions with our customers and our suppliers. So we have to ensure that our customers and suppliers are protected with respect to the patents that we're divesting, while at the same time giving the third parties that we're divesting to enough control to monetize the patents on our behalf, monetize the patents and obtain value that way. So that's one of the tensions that we went through for multiple years in figuring out a way to achieve value for our patents other than us going and monetizing them ourselves. Because the other option, of course, is for us to take our patents and find potential infringers and enforce our patents against them. But it doesn't make sense from a business point of view when that monetization strategy doesn't yield significant royalties eventually for us. So we decided that the best way to do that is to divest and have a third party take over, obtain value for them. Another aspect of working with management and demonstrating the value is not just for our patent portfolio, but we have products in the marketplace, and it's inevitable that somebody will have patents or large portfolios that apply against our products. And so we have to, one of the jobs that my group does is demonstrating to management, determining first whether those patents in the marketplace have any value, and then demonstrating that value to our management. And these items, you may think that it is an easy thing to do, but it's not, because when we're getting cash in, it's always it's easier to convince management that there is a benefit when we're getting cash in versus when we're paying cash out. It's natural. You can, everyone can understand that. So when it really, there is a lot of analysis that our group has to do, technical analysis, to show working with technologists within the corporation to show that these patents portfolios that somebody else is bringing to our table really does have value. And a few percent of, like I would say 25% of the portfolios that are brought to us do actually have value that we should take a license for. And we end up taking a license. We have to find the right rate at which we want to, at which we license those as well, because it is a tendency of licensors to ask more value than there is, primarily because they assume that because they assume that more products than actually are using the technology. I think that's pretty much all I wanted to cover. So my work is primarily from a patent side, 75%. 25% is probably from trademarks, brand enforcement, technology licensing, etc. So that's where I concentrated, where I focused this discussion. But I'd be happy to take questions as they come along. So thank you.
Great. So, Soji, I'll start off with the brand protection. Michael, Soji, great conversation on patents. I'm learning a lot, especially as the industry expands with cannabis, especially out here in California. My name is Kevin Olive. I'm a brand protection investigator with UL. I have been working with UL for about 6 years now, and prior to, a little background on myself, prior to working for UL, I worked law enforcement for 30 years, with 15 of those years being investigations of various types, with the last 5 of those investigative years being IP enforcement. Now, you got to understand something about IP. IP crime back in LA, or back where in LA County, wasn't a high priority crime. It wasn't even known. So you can imagine we were seeing a lot of IP felony crimes just going by the wayside. So with that, I transitioned from working IP investigations to UL investigations, doing crime, IP crimes. So it's a great job. It's a great position to work for. Now, so our topic is, how do we just demonstrate value? Well, that's a good question, and that's something we talk about all the time. I mean, we know that that consumers see a brand product, and when they look at that brand, they attribute it to performance, quality, and is it safe to use? Now, let me back up a little second here. Working for UL, our brand appears on approximately 22 billion products annually. We don't own any of them. So we add a lot of value by not only protecting our mark, because we know that mark stands for safety, but we also protect our clients' brands as well. And our companies, these brand these companies' reputations, brand reputations are determined how they perform on the market. So if they're being counterfeited or they get a bad publicity regarding one of their brands, that's not good. We know counterfeits out there. We know it's running rampant. Okay, in industry and countries, everything is subject to counterfeiting. Trade design rights are violated, or as Michael and Soji's talked about, patents. How do we help with that? How does a brand protection manager? Now, I'm not an attorney, I'm an investigator. I investigate IP crimes for UL. So how do we add value? We add value by mitigating the losses, preventing them, and not in just a reactive, oh, we see a counterfeit mark here, let's go after it, but we proactively go after them. We by emphasizing prevention, and using a priority-focused, intelligence-led, project-based approach to our anti-counterfeiting actions. So we're looking at all of our projects. We're looking at the counterfeiting. We look at the data that we have collected over the years on different counterfeiting actions that we've had, and we analyze it, and then we target the specific ones that are really high and have a tremendous safety value to the public. That's one of the things we do. So how do we do that? How do we do these investigations? How do we look at these priority-focused investigations? We start off by establishing partnerships with law enforcement. Partnerships with different brands, conferences like these. UL has prior to COVID, we had a significant amount of conferences that we would come together and collaborate on on these IP crimes and bring awareness. One of the things that I truly enjoyed to seeing, because as a detective with the Sheriff's Department, even the prosecutors didn't understand how to investigate or even file IP crimes, and sometimes we had to explain that to them. So these conferences help. We establish training sessions with customs, with law enforcement, and we go out actively seeking for these trainings. We train individual units, we train task force, and the results of these trainings leads a great deal of benefit for us and shows our value by custom seizures. When the customs sees a bunch of products that have counterfeit marks on it, those marks or those counterfeit products don't enter the global marketplace. We do a lot of federal, state, and local training, and so when those actions occur, when those law enforcement actions occur, again, we're taking this counterfeit products off the market. That's showing value. Now, again, I've stated I'm not an attorney here, so I don't sue anyone, but sometimes you have to go after the counterfeiters, and sometimes you have to sue them, okay? And that's one way. One way I've determined, or one way I've saw that significantly affects counterfeiters is when you hit their pocketbooks, when you really take a big chunk out of their finances or their money. It has a great impact on them. Okay, so civil seizures or civil settlements are great examples of how a brand protection team can put together a case and submit it to their attorneys for civil actions. Now, does it always result in a monetary award? No, it doesn't always, because you get an award, but the counterfeiter goes out of business, disappears, and what are you stuck with? You're stuck with that. You're not stuck. You're left with a judgment that can be used. So when you're addressing other counterfeit issues, you can take that order or that court order or that court judgment or that court action and say, hey, this is what we do. This is how we went after it. And this is what we plan to do if you don't cease and desist, if you don't stop your actions. So that's a non-monetary value that we bring. You know, if we continue to go after the counterfeiters, we're proactive. You have to stay ahead of this game when it comes to counterfeiting, because as technology changes, so does the counterfeiters. Trust me, counterfeiters know exactly all the techniques. We're being introduced to payments by cryptocurrency. How many have heard that word before? Cryptocurrency being used to finance counterfeiting actions. You have to stay on top of it, being proactive. Watching the online marketplace. We have increased our online presence, and being proactive like that, we've added value. We add value to the business because that's an additional protection, layer of protection that we offer for our brand and our clients to remove that stuff off the marketplace. So pretty much I didn't want to go on and on and on, because when I get going on, especially when it deals with counterfeiting, I mean, I could talk forever on counterfeiting and the emerging market as it deals with cannabis. That's a great market, but I'll pass it on to my partner, Pankaj.
Thanks, Kev. This is very passionate of you to have shared your insights and experience. I would just like to begin. I mean, I have the unique distinction of being an investigator and an attorney, and also working in a corporate, and now having my career 2.0 there. So I work for Lall and Sethi, which is South Asia's finest and premier IP boutique law firm, and we focus on all the IP laws, trademark, copyright, design, patents, and brand protection specifically. I'll be introducing this concept later today in the conference of total legal and business solutions, addressing counterfeiting and diversion, tampering, trademark infringement, supply chain integrity issues holistically. Our firm provides a complete range of award-winning services, including filing and prosecution of applications, opposition, cancellation proceedings, searching and watching services, renewals, licensing, register user, franchising, IP audits, investigations, and enforcement actions. We take pride because we have our own litigation department, and we lead all the civil, criminal, and administrative actions directly. We are a firm having a strength of 100+ members. We are 6 partners, and we are. I mean, 100 members may not sound you guys in the US to be a big law firm, but we would take pride. I mean, we are very focused, and we are one of the mid-size and growing to be a large-size firm. We are having offices in Delhi, Kathmandu, and Colombo, soon to be open in Dhaka and Singapore, which is where I'm based. We've got several associate offices and investigation hub in India, South Asia, and Southeast Asia. And then coming on to bringing value out of enforcement actions, I just want to share about some of the peculiar and successful orders which our firm has been able to get. I mean, they're typically John Doe type orders. Police assistance on a short notice, getting orders to break open the locks because these counterfeiters are really smart guys, and they sometimes get tip off. So they would close their premises, and specifically, I mean, so we have taken orders from the court to break open the locks in case we find the premises to be locked. We've got a huge huge kind of a benefit wherein the courts have actually directed the manufacturers of infringing products to be basically giving some sort of a compensation, and then we got some monies towards them. Forcing them to do some community service for the welfare of children. We got recoveries from counterfeiters, and also have a distinction of conducting multi-point raids in multiple cities and states in the country simultaneously. We also offer customs recommendations and customs awareness and enforcement programs, and we would have our intelligence unit, which would just pick up signals and collaborate with custom authorities for seizure at the ports, and thereby thereafter destruction of those. Just to share, and I was mentioning it to you, Kevin, earlier, that I have a 22 plus years experience. Now I'm partnered with Lall and Sethi, heading their brand protection program, strategically based out of Singapore. But I have spent large chunk of my life doing investigations, enforcement actions, and supply chain integrity programs, etc. So I have spent a considerable amount of time with Johnson & Johnson and with GlaxoSmithKline, leading their brand protection function in Asia Pacific. So I've spent 15 years with them. I would say, I'm still a student, but people would consider me having some knowledge of brand protection, and I've been co-leading INTA's anti-counterfeiting committee in South Asia, and I've been part of some global initiatives on COVID-19 awareness projects. Just wanted to share very quickly on what could be the approach and what could be the philosophy of companies and essentially of us law firms when we come to building a brand protection philosophy, right? So the ideal brand protection would require some proactiveness. It has to be highly strategic. We would look at developing a holistic, evidence-based program. There are many forms of detection and response, but we also need prevention, analysis, and learnings from that. We see all and majority of our clients. We represent Fortune 500 companies, and many of them are having their brand protection programs. Some are, and all of them, I would say, they're not at the same maturity level. Some are just getting started. Some are way ahead in the process, and they may be having a solid strategy, but in terms of tactics on ground, they need that guidance and influence from a law firm. Virtually every function of a firm and an enterprise can play a role in brand protection. The roles can vary in substance, breadth, and depth, but the only point that I would emphasize is that it needs to be a concerted effort and a consistent approach to brand protection. The categories of tactics demonstrate a variety of approaches that can be employed across the stakeholders, across the enterprise, across companies. And brand protection really calls for a layered strategy. And the most effective programs will really be where we have a deep implementation of the tactics across the enterprise. This is, and I wanted to share. Before we get on to as to what could be a plausible, effective enforcement strategy, which will help you yield your desired objective, be it in terms of be it in terms of return of investment, be it in terms of achieving patient safety, be it in terms of acting and positioning ourselves as a market leader, or be it causing impact, causing a deterrent effect by doing some impactful action. So I'll touch upon that very briefly. But what I want to describe here essentially is a brand protection strategic roadmap, and essentially, I mean, how we go about, and this is a typical problem-solving activity, not a rocket science, but we have customized it to basically suit the brand protection needs. So objectively, we have to ask ourselves, I mean, we start with problem recognition. So there needs to be an acknowledgement of the fact that there is a problem, and then essentially the whole thing sets into motion, whereby there would be risk assessments conducted so as to quantify and size the problem, which is very important because once you are building an enforcement approach, you need to know as to what problem you're trying to solve and how big the problem is. Because you can't be firing a cannon if the issue can be solved with a needle, so to suggest. When it comes to strategy development, it needs to look into, and there are various tools which we deploy in terms of conducting a risk assessment for the entire supply chain, or looking at the product risk assessment, or maybe a technology selection tool. And once the strategy has been developed, we could look at strategy implementation, and then I mean, basically measure our performance and do a continued assessment so as to we can go back to tweaking our strategic approach and fine tuning it and getting the desired results. This is largely the blueprint, which is what I have consulted many people, and essentially I've deployed and applied this during the last 20 years of me being part of brand protection domain and field. So this is it all starts off with assessment, and then getting on to protect, monitor, respond, influence, measure. And this is the framework which we think would be useful for companies and for the governments and for the consumers alike when it comes to brand protection approaches. I'll touch upon very briefly, I mean, what you can do from a protect standpoint and from a response standpoint. So when it comes to protection, I'll simply say, I mean, we need to register our intellectual property, and we don't have to restrict ourselves only to the markets where we sell our products, but we also need to register our intellectual property in the markets where essentially we would see some sort of probability of counterfeit occurring. Then we look at customs recordal, and then looking at adding product authentication features. So that's basically, I mean, building a fort, so to speak, wherein you have your IP registered, you have your customs recordation done, you would have some product authentication or product protection features on your product, and this will help you when you monitor your product in the market, and when you respond to either the incidents of counterfeit and essentially manage. And then there are ways and means to respond, which is what I was alluding to earlier. So you could look at criminal options, criminal raid and seizure action. You can look at civil enforcement actions, and essentially looking at administrative actions, and then the customs is there. The enforcement strategy needs to be a judicious mix of all four of these remedies which are available to the right holder, and it all dwells down as to what is the problem that you are trying to solve. So I'll just pause here. I know I mean we would be running out of time, but I want to take some questions as well if there are any. But largely, I mean, this is what I feel I wanted to share with all of you.
All right. Thank you so much, Pankaj. Thank you, Pankaj. Thanks, Michael, Kevin, Soji, for a wonderful session. And we also have some of the comments on the chat box, and I think you all have read that. So we have from Berit, that is great strategy. Soji, thanks for sharing the insight. We have a comments from Smriti Mohan. I truly enjoyed the presentation. I spoke on this topic during the last IPR conference. It was wonderful for me to hear additional new perspectives as well as additional protection and enforcement strategy. Thank you all. So thank you, participants, for contributing in the session, and all the speakers who have joined in today. All right, thank you so much.
Thank you, Kev. Thanks, Mike. Thanks, Soji. Interesting discussion. Thank you so much.
Bye bye.
Thank you so much.
Bye.
Thanks, everyone.
Bye from here.